Hi everybody and welcome back to our Workplace Compass podcast series. I am Jess. I'm a legal director and knowledge lawyer in the employment team here at VWV.
And I'm Kiki, a partner in the employment team. And in today's episode, we're continuing our series on the latest Employment Rights Act 2025 updates by focusing on the flexible working changes.
Yeah, so flexible working is a topic that affects obviously lots of employers and employees, especially as workplaces continue to adapt post-pandemic. Recent ACAS survey, interestingly, has found that work has placed changes to flexible working in the top 3 of the changes under the Employment Rights Act that most likely impact them. We are going to just explore the changes that the Act is going to make. The current consultation is open and what flexible working is going to look like moving forward.
That's right. So we'll look at the consultation's key proposals, the risks of getting flexible working wrong, and the practical implications for employers. So let's start.
Yeah, so it's probably worth starting with the legal position. So under the statutory flexible work request regime, compensation for mishandling a flexible work request is relatively limited. So the maximum is 8 weeks pay, subject to the statutory cap. But I think it's really important actually not to take too much comfort from that, from thinking, oh, it's a relatively low amount of compensation, because the real risks here are often much broader than that headline compensation amount.
Exactly. In practice, flexible working is often closely linked to issues like childcare, disability, and other protected characteristics. So if a request isn't handled properly, it can very quickly give rise to discrimination risks, and those claims can carry uncapped compensation.
Yeah, and of course, as well, beyond the legal risk, there are some very real people and business considerations to take into account as well. So how employers approach flexible working can have a direct impact on staff retention, engagement, as well as staff morale. And so particularly in what can be a competitive labour market, flexibility is a sort of key expectation for many employees.
Yeah. And there's also a reputational angle, I think, travels quickly, both internally and externally, I think, about how flexible working requests are handled. And that can affect your ability to attract and retain talent, as well as how the organisation is perceived more broadly.
Yeah, so I think then what this means is that although the statutory framework might look quite limited on paper, in reality, this is an area that employers will really want to get right, because it really matters, not just to manage legal risk, but to also support the wider workforce strategy.
So, with that in mind, what is the Employment Rights Act 2025 changing about flexible working?
Yeah, so there are currently 8 statutory business reasons for refusing a flexible work request. And they cover things like the burden of additional costs, or being unable to reorganise work amongst existing staff, or there being a detrimental impact on performance or quality. Those statutory business reasons are not changing, but some new requirements are going to be added. Firstly, employers are going to need to ensure that it's reasonable to refuse a request based on those specific grounds. And then also, when notifying an employee of a refusal, employers are going to need to explain why they think that it's reasonable to refuse the request on those grounds.
So essentially, it sounds like employers will need to provide more detailed explanations when rejecting the flexible working request, and those decisions could face greater scrutiny if challenged.
Yeah, I think that's right. So I think there's some comfort to offer to employers here, as the government is going to be publishing guidance on how to approach the current requirement to consult with employees before refusing a flexible work request. And we're also expecting an updated ACAS code of practice on flexible working as well, which is going to help navigate these changes.
So these changes, along with the new guidance and code, are expected to take effect in 2027 following the consultation. What do we know so far?
Yeah, so the government launched this consultation in February, and it focuses on how flexible work requests are handled in practice, and particularly that consultation process and the introduction of that new reasonableness test. So of course, we have to be clear here that employers are already required to consult with an employee before rejecting a flexible work request.
Yes. So what the consultation is really doing, I suppose, is looking at what that consultation should involve in practice. Because at the moment, the requirement's quite high level and it is applied inconsistently.
So it's about adding more structure and clarity then, I suppose.
Yeah, exactly. And I think the consultation suggests a more defined process. So, for example, a meeting between the decision maker and the employee without unreasonable delay, keeping a written record, and then clearly communicating the outcome.
So the key shift is the emphasis on meaningful consultation, and the expectation is that employers and employees are going to genuinely explore what might work rather than quickly moving to a refusal. So that will include discussing practical challenges, considering whether the request can be adapted, exploring alternatives perhaps, looking at different working patterns, phase starts, or even trial periods.
Yeah, and I think that ties into the new reasonable test. So if an employer rejects a request, they'll need to show that the decision is reasonable by reference to one of those existing statutory business grounds, which you spoke about earlier, and then explain why that applies in the particular circumstances. So employers will need to be much clearer on their reasoning, not just the outcome.
Yeah, and I think it sounds like the government does recognise that this could be more complex in practice than it might first sound. So that comes through in the consultation, which is asking for feedback on what guidance and support employers are going to need to apply this new framework effectively.
So all this is due to come into effect in 2027, but we are already receiving lots of questions about it, and we know it's an important topic for employers and employees alike. So in terms of what employers can be doing now to prepare, I think it's about reviewing how flexible working requests are currently handled in practice and whether managers are equipped to have those conversations. And also, I think having a clear understanding of how work is organised within your organisation and why will it make it much easier to respond sort of consistently and confidently to requests under the new framework. So if you work in a sector or organisation where flexible working is typically considered less achievable for any reason, you might want to test why that is the case and indeed whether it still remains the case, in the modern world of work now. So the consultation closes at midnight on the 29th of April, so there's still time to respond if you want your views to be taken into account.
So to recap then, the Employment Rights Act from 2027 is going to just introduce more structure in the approach that you need to take when you're handling flexible work requests, including that clearer consultation process and the new reasonableness test. But in the meantime then, as you say, Kiki, employers may wish to just review how they're handling requests currently and make sure that line managers are equipped to have those conversations in order to ensure that you're following a fair and consistent approach.
Yep, I think that's right. So thanks everyone for joining us for this episode of the Workplace Compass podcast.
In our next episode, we're going to be looking at some of the other consultations that have been launched on more of the Act's key provisions. So if you found this episode helpful, please do like and subscribe to our Workplace Compass series so that you don't miss any future episodes.
Yeah, and we really hope you can join us again next time.
And until then, bye for now.
Bye.